Welcome to this new European Administrative Law Dialogue. My name is Mariolina Liantonio. I'm a professor of European and Comparative Administrative Law at Maastricht University, and I am also the general editor of the Review of European Administrative Law. And this initiative that we are in today, the European Administrative Law Dialogues, is an initiative of the editorial board of the Review of European Administrative Law. And the idea behind the initiative is that we select a number of topics that are of relevance for administrative lawyers at large, and that are aimed to bring together prominent speakers in the field of administrative law to also try to build a community in Europe and also outside Europe centered around topics of European and comparative administrative law. And today we have the pleasure and honor to host with us Professor Edoardo Chiti from Sant'Anna School of Advanced Studies. Professor Chiti is a well-known author in the field of EU administrative law, but also comparative administrative law, and part of the school who has done a lot of research in the field of global administrative law. And he's currently working on a number of issues of more theoretical nature linked to the transformation of administrative law in the interplay between global, European, and national legal orders. And today, Professor Chiti will present his forthcoming paper that is titled Against Administrative Law: Reasons, Arguments, and Implications of a US Debate. So thank you very much, first of all, Professor Chiti, for accepting our invitation to come and present your work in the framework of the European Administrative Law Dialogues. Professor Chiti will be accompanied today by two discussants, Professor Susan Rose Ackerman, who is a professor emeritus of law and political science at Yale University. She is a very prominent name in administrative law worldwide. She has done a lot of work on anti-corruption, government accountability, and also prominently in the field of comparative administrative law. She has co-edited the book Comparative Administrative Law in 2017. If I can do some promotion, the third edition is on its way, so stay tuned if you are interested in comparative administrative law. And the second discussant, so thank you very much, Professor Rose Ackerman, for accepting our invitation. The second discussant today is Professor Thomas Perroux from University of Panthéon-Assas. And Thomas Perroux has also done a lot of work on administrative law and also very much on comparative administrative law, also in a transatlantic way, so to speak, between European countries and the US. So both discussants today are really particularly well suited to share their ideas on Professor Chiti's forthcoming paper. So without further ado, I give the floor to Professor Chiti for a presentation, and then after first to Professor Rose Ackerman, and then to Professor Perroux for their discussion. Thank you very much. Edoardo, the floor is yours.
Okay, many thanks, Mariolina. Many thanks, first of all, for your super generous presentation of my own work. And many thanks to you and Professor Maric, of course, also for the hospitality in this very interesting series of dialogues or concerning European administrative law. It's a great pleasure to be here. I'm not saying this, because of reason of courtesy. It's because it's something that I really think. Let me share the screen with you because I have a very short PowerPoint presentation, so don't worry too much. It's just 5 slides, and the first of which is what you should see now on the screen. Just confirm me that everything is fine and you can see it.
Yes, absolutely. Yeah. All good.
Okay, so what I'd like to do today is to share with you some thoughts about this quite interesting development of US administrative law that Mariolina was recalling, namely the emergence and the consolidation of anti-administrative thinking in the US. And in order to do this, I will divide my short presentation in three main steps. First of all, I will try to recall the fundamental terms of this ongoing American discussion against administrative law, and this will be the more informative part, but I think we need it. Second, I will try to explain this debate or to find an explanation to this debate, and my explanation will be mainly a legal historical one. And third, I will say something about the relevance of this debate for European administrative law and for European administrative law scholarship, also to justify why we are discussing this topic, this issue, this subject in the context of this specific series of dialogue, of meetings. So the first, my first step is the one concerning the critiques that are brought to administrative law. And I think first, a fair summary might be to say that there are three main critiques, and I should say immediately that none of them, for different reasons, is convincing, at least from my side. This is what I will try to argue. Now, the first critique is directed not at administrative law as such, but at the administrative state. And it revolves around the idea that the principle of separation of powers has been violated, and it has been violated by the development and the consolidation and the expansion of the regulatory state, because federal agencies have accumulated over the years too many powers. For example, Christopher Walker has observed in an article which is quite paradigmatic of the approach taken by those who oppose the consolidation and expansion of the regulatory state. He has observed that federal agencies dominate lawmaking today as Congress cedes more and more policy-making power to its bureaucratic agencies, and this calls into question the separation of powers between the two branches of the government that are provided for in the Constitution, and that this is a violation also of the rule of law values asserted by a number of authors such as Locke and Montesquieu. Now, if this is the diagnosis, if this is the problem which is identified by Christopher Walker and many other authors taking the same position, then it is not surprising that the possible solution is to be found in the restoration of the Congress role. So the idea is that Congress must return to its core, to its fundamental constitutional function of regularly passing laws. And this has to be accompanied by a reduction of the size and scope of the regulatory state. Another proposal coming from this diagnosis is that we should keep administrative rulemaking under judicial control. So not only under the control of all the legal institutes and rules and principles of administrative law, but a control that has to be ensured by the judiciary as such. And this, of course, has to do with the Chevron doctrine, which has to be revised from the point of view of these authors, and which has been actually revised, as we all know, in Loper-Bright in 2024, in the first half of 2024, although the revision, perhaps we can say something about this later on, but the revision is not so radical as it might have been, I think. So this critique to the regulatory state is quite clear, and it is also, I should say, from my point of view, simply untenable. I mean, it's unacceptable, I would say. And for different reasons. Some of them are formal and strictly legal, but my main argument against this position is functional, and it revolves around the idea that the administrative state actually represents an indispensable component of contemporary polity. So you cannot do without, realistically, you cannot do without the regulatory state if you want to implement a rather complex or an over-complex political agenda, as it is the case in all contemporary polities. And here, for example, Julian Metzger writes, I think very appropriately, that the question is not whether an administrative state will exist, but rather what will be the scope and the focus of the activities of the regulatory state. So my main reaction against this first critique is functional. It's unrealistic to imagine that we can do without the regulatory state. Then we have a second critique, which is directed at administrative law in particular, specifically, and not at the regulatory state more generally. And of course, this is the position taken by the super champion of anti-administrative thinking in the US, Philip Hamburger, who has argued in this book, which it begins, the title is a question, but it's a rhetorical question, because he has argued in this book, very long book, that administrative law, US administrative law in particular, is certainly unlawful, unconstitutional. It is a form of governmental power, he writes many times and repeats many times in the book, outside and above the law. This is the formula that he uses in developing his argument. And this is contrary, from his point of view, to the founding rationale of Anglo-American constitutional law. Of course, this critique goes back to Albert Vendice's position expressed in relation to English administrative law at the end of the 19th century, which is brought within the US context. But again, this critique is, from my point of view, from the point of view of a public law scholar, an administrative law scholar, working mainly on EU law or European law more generally. My reaction is that this position clearly fails to recognize, first of all, that the history of English administrative law itself dates back, or that there is an administrative law even in England, and that its history dates back at least to the Victorian era. And then, and moreover, if we follow the reconstruction proposed by Paul Craig in his latest book, we can even identify or register the existence of administrative law in England since the early 16th century. So this is a problem with Philip Hamburger position. And the second problem is that it is based on an obviously reductive interpretation of administrative law, which is seen by Philip Hamburger as an instrument for power establishing only, so as an instrument to reinforce the powers and the privileges and the prerogatives of the executive, while administrative law has been historically a much more complex component of the legal system, first of all, because it is oriented both to power establishing and to power checking. The third critique is more nuanced and more subtle, and it argues that administrative law is illiberal, or it has become illiberal. It has undergone an illiberal twist because of the jurisprudence of the Supreme Court, because of the choices made by the Congress itself, and also because, of course, of the practices developed by the federal agencies. Now, this position is expressed, I think, in very sophisticated, I would say, terms by these two authors that you find mentioned here in the text of the slide. And it has the merit of recalling, I would say, the liberal ethos of administrative law. So the nature of administrative law is a project of institutional design oriented to ensure that we need to keep the exercise of administrative power under control in one way or another. The problem with this position, with this critique, is that it contains an appeal to the liberal rationale of administrative law without, however, telling the readers which practical solutions we can identify. These two authors and many other authors following the same line have in mind a number of solutions, but mainly their idea is that all the main constitutional doctrines concerning concerning the position of the administration within the constitutional framework should be revised, and therefore Chevron should be revised, but also the non-delegation principle and all the other doctrines of US constitutional law, which is something, again, unrealistic. I mean, we should find other ways to revise, to recover the liberal nature and ethos and spirit of administrative law. So we have three main critiques that I have presented in an oversimplified way. I know that. None of them really convincing. This is my main point at this first stage of my presentation. Then let me move to the second, to my second point, to my second step. How can we explain the rise of anti-administrative thinking in the US? Why we have, this anti-administrative thinking in the US and not in Europe, for example? How can you explain this? Well, here the main, the most common explanation points to the current political circumstances of the US politics, and therefore it is normally argued or commonly argued that the three main critiques of anti-administrativism should be seen as a reaction to the extensive regulatory program elaborated and carried out by Obama in his presidency. So, the idea here is that there are very specific reasons connected or depending on the specific circumstances, current circumstances of US politics. And so it's the product. Anti-administrative is the product of this specific situation. Now my understanding is different, and I'm interested also in understanding your or in hearing from you and understanding your position on this. My understanding is that there is a deeper and more interesting explanation, I would say, and this explanation points to the long-term legal history of US administrative law. And in particular, it points to the fact that we have, or I see, or not only me, of course, but I think there is a fundamental and unresolved legal issue in the legal history of US administrative law and its position in the constitutional framework. Now, let me go back to the end of the 19th century. Where at least three positions confront each other, because this is a way to understand the kind of debate that there was at that time, and that has conditioned the development of US administrative law later on. The first position is the one which goes back or follows Albert Vendaisy and the position that this prominent common lawyer has elaborated at the end of the 19th century in England, and with respect to English administrative law in particular. So the idea is that we need to radically remove both administration and administrative law from the American constitutional horizon, because there is no room in the American constitutional horizon for administration and administrative law. So this is clearly a reflection or an importation in the American context of the negationist interpretation. Negationist interpretation is the expression that Bernardo Sordi uses in the first two editions of the book edited by Susan Rose Ackerman and others on comparative administrative law, which I find an appropriate expression. So we need to deny the existence of administrative law as such in the US context. The second position is, my favorite one, is Frank Goodnow, who does something completely different. He takes the opposite approach. And he says, we can and we need to transfer the continental model of the European continental model of administration in the US context. And the European continental model of administration basically assumes that there are two main functions: the legislative function, according to which the legislator expresses a sovereign will, and an executive function which requires that this will, which is expressed, of course, in legislation, requires to be implemented at various levels, including the administrative level. And it does this operation of reinterpretation of the US constitutional framework in light of the German and the French constitutional framework in 1893, in his famous book on comparative administrative law, which has a number of doctrinal consequences. But, and this is the interesting thing, it's an attempt which is completely marginalized. It's completely unsuccessful, at least in his radical attempt to apply a European continental model to the US context. It is very successful, or it has been very successful on other levels, but not on this in relation to the specific idea that we might import the European continental model. But in a sense, the existence of Goodnow and the idea, the provocation of Goodnow produced or opened the way to the search for a third option, which is exemplified by many different authors, but mainly we may refer to Bruce Wyman, who argues in the very early years of the 20th century, in particular in his book on the principles of administrative law, that a middle way between the other two positions is possible, and this middle way assumes that you need and you actually may reassert the constitutional doctrine of the separation of powers, while at the same time recognizing the possibility of a legislative construction of a federal administration provided with regulatory powers. So the legislation is, of course, the key, the channel, the institutional channel through which we may introduce the regulatory state in the US constitutional framework without at the same time denying the constitutional doctrine of the separation of power or reasserting this constitutional doctrine. Of course, all the legal developments following the New Deal are a decisive historical, a crucial historical passage, because they formalize, so to say, this third option, this third understanding. But what is interesting is that the New Deal did not really solve, or the legal developments following the New Deal did not really solve the fundamental ambiguity of Wyman's understanding of administration and administrative law in the US constitutional framework. Because the fundamental ambiguity of that position is that it assumes that the US administration remains, I don't want to use Philip Hamburger's words, but it remains an extra constitutional administration because its prerogatives cannot find their foundations in the general principles of the legal system. That's the problem. They can be justified as the product of specific manifestations of the legislative will. So there is this tension, there is this ambiguity in the choice which is made in the 30s and which has been confirmed over the years until now. And if we consider this, oversimplified legal history of US administrative law and administration, then it's clear that what we see now, the position of Philip Hamburger, of Christopher Walker, and many other authors, is simply, the reemergence of this fundamental ambiguity, or a confirmation that this fundamental ambiguity has not been really solved or solved once forever. Okay, and that we need, we are still in search of, or they are, the Americans are still in search of a solution which really stabilizes the role of the public administration within the constitutional framework. And this means that Goodnow was right. I mean, that Goodnow had the idea which had the merit to be the radical idea, the radical solution. He provided the radical solution to this issue. And precisely because this was a radical solution, it has been rejected or it has been marginalized in subsequent debate. Now, let me go very quickly to my third and final point, because I think I'm speaking too much. But final slide, very briefly. This is a very much an American debate, and that's interesting. No? It's purely internal to a legal culture, to a political sensitivity, even a judicial sensitivity. But of course, it's fascinating also for European public law scholars, and not only for, let's say, intellectual reasons. It's interesting also because it may teach something to the European administrative law scholarship. And I would like here to point to two main aspects of relevance for us Europeans. These are two suggestions or 2 points that we can take from American administrative thinking, but in a contrastive way. That is to say, by using anti-administrativism as a contrasting model, as a model that can teach us something about, something very different that we should focus on and reflect on. So 2 main points. First of all, I think that American anti-administrative thinking recalls us, as I was saying, in a contrastive way, the complexity and diversity of the experience of the administrative state in Europe. Why is it so? Why am I saying so? Well, American anti-administrative thinking assumes that the regulatory state, or the wide expansion of the regulatory state, is an instrument of collectivism. It is an instrument of a specific political agenda characterized by a strong intervention of the state in the economy and so on. But this is not true historically. I mean, historically, the administrative state has not been necessarily an expression of collectivism and an expression of public interventionism. It has been instead a type of state which may be oriented according to the cases or the situations or the circumstances, both to liberalism and or either to liberalism or to collectivism. And the point is precisely that, the regulatory state does not have its own normativity. Sabino Cassese wrote somewhere that the regulatory state is a chameleon. I don't know if this is the correct pronunciation, but the animal who changes the color of the skin according to the environment. And I think it's a perfect representation of what the regulatory state is. The regulatory state is characterized by its capacity to adapt to different types of public policies. So the first lesson that I think we can learn from American anti-administrative thinking is that they are wrong. We need to recognize the plurality and diversity of the regulatory state. And once that we realize the plurality and diversity of the regulatory state, we have, the possibility to understand its internal organization. So there is, so to say, a research agenda beyond the recognition that the regulatory state is a hugely diverse and complex and internally articulated project. And the same more or less applies to administrative law, which is, the legal machinery of the administrative or the legal tools of the administrative state. Again, here, anti-administrativism assumes that administrative law is an instrument of power establishing. But historically, this is not true. History tells us very clearly that administrative law may be oriented, first of all, to at least to 2 different purposes: power establishing and power control. So one thing and its opposite, basically. But in addition to this, history also tells us that the rationale of administrative law is somehow multifunctional, because administrative law may be used to pursue different substantive policy objectives. Now, why is this important? And I'm closing with this statement. Well, it is hugely important, I think, because it tells us that administrative law is not a value-oriented body of law. It's not like constitutional law. It does not have its own normativity, its own normative sensitivity, normative orientation, and so on. It is, it has a dark side, so to say, in the sense that it may serve many different masters. It may serve many different policy objectives or political agenda. It's a law of, amorphous, more or less amorphous technologies. It's malleable. And this is, as I was saying, the dark side of administrative law, but it also, the great potential of administrative law. This is basically ambiguous, but it has also this great potentiality because it characterizes administrative law as a project of institutional design that policymakers may shape and that we as scholars may also shape. And this is my last statement. Sorry, I spoke too much. I apologize for this. But many thanks for listening, and now I'm ready for the execution. I hope not.
Thank you very much, Edoardo. This was extremely fascinating. But without further ado, I give the floor immediately to Professor Rose Ackerman for a first round of comments. Susan, I think you are still muted.
Okay, you can hear me now? Good.
Yes.
Okay. Thank you. So I was a little alarmed by the title of your paper when I first saw it, and then I was very glad to see that I'm pretty much on the same page as you are. And I wanted to develop some of the points that you are making in connection with some things that I've been mostly more thinking about. So I quite your three your criticism of the three arguments being made, and I of course would pick up on Gillian Metzger's comment about that the issue about administrative law is not its existence, but its scope and focus. And the basic idea that in a modern democratic state, it's simply unrealistic to imagine that the legislature is going to write laws that get rid of the need for some kind of judgment being exercised by the administration. There's going to be a bureaucracy out there if we want to try to solve any of if the government wants to try to solve any of the big problems facing the modern state. And so the process, in other words, some of the people I think who are objecting to the administrative state really are objecting to the substance of the things that the government is doing, and that have large implications for the way people and businesses are operating. And so it needs to be understood that many people are coming from that direction. And that if people on the other side who are wanting the state to try to solve various problems that are not solved by the market or by individual choice are going to be stuck with bureaucracy, whatever its benefits and costs. And part of what administrative law is trying to do is deal with some of the difficulties of delegating power to others and trying to both control the integrity of the way that system works and the democratic legitimacy or the public legitimacy of the policy choices that they're going to inevitably be making given that the statutes aren't like covering every little thing, right? And then secondly, I very much would go along with your critique of Hamburger's claim that U.S. administrative law has drawn too heavily from racially Prussian administrative law. I have two former students of mine who have written very good papers on this. One of them, Martin Rosbach, German scholar who studied in the U.S., who was pointing to the fact that the development of U.S. administrative law, although many of the people who were engaged in developing it had some knowledge of the development of administration in Europe and particularly in Germany, that the underlying American constitutional commitments show up in U.S. Administrative law. It shouldn't be seen as some kind of, you know, sort of nasty borrowing that has gone on. Another former student of mine, Jed Matthews, who's an American but with a long interest in Germany, collaborating with a German younger German scholar, Spanos, was looking at it the other way and trying to say, look, we actually study Germany, we see that it doesn't conform with the kind of caricature of it that Hamburger is presenting. So it's sort of criticized from both sides. If you're interested, I have to brag here. If you're interested, this is a book here that I edited that is, it probably comes out to me, I'm looking at it, it's a mirror image, but it's from a conference that was in my honor a couple of years ago. You want to, they develop the arguments that you're raising in I think very important ways. Let me spend a little more time on the third argument. My own thinking about administrative law, a lot of the things that are of concern is the way in which democratic values should be expressed through the way in which the public administration operates. And that's a complicated question about how that should be done. In other words, not thinking about it as just simply, well, the democracy enters in the legislature and they pass a law, and then you switch it over into the bureaucracy, which is supposed to, like, in a kind of technical expert way of carrying things out. Well, that's part of it, but the thing that's particularly concerned me is trying to bring democratic participatory values into the way in which the administration operates. And an important comparative difference between the United States and Europe, and in fact, most of the world, is that we have something called an Administrative Procedures Act that applies to rulemaking. Now, it's true, it's not that because we have this old, hard to formally amend Constitution, I would say de facto it's been amended in many ways, but the details about the administration don't show up very much in the Constitution as written, but it's still there as an important question. So that an important part of, for me at least, thinking about administrative law is the way in which the processes by which it operates, by which it produces rules in particular, as well as things having to do with individual adjudications, the way in which those processes are structured to reflect the underlying constitutional values of the country. And it's been interesting to me to see that the part of our US APA that covers rulemaking, in other words, the requirements for notice, for hearings, public hearings, where the administration can't pick who they're going to hear from, right? They just have to say in the Federal Register, we're opening things for comment, and written reason giving, public written reason giving, and then a judicial review based on whether you followed those processes. That's just one aside. The Loper Bright case did not have to do with process. It had to do with a substantive interpretation of statutes, and to me, it completely ignored the complicated relationships between law and policy. It seemed to assume, even in the guys on the left, it seemed to assume that it was very easy to say, okay, this is law and this is policy, when half of what we're talking about is where they're mixed together. But in any case, the interesting thing to me is that however imperfect the APA, the rulemaking in the APA is, and it's extremely imperfect, it's expressing to me some important values of involving and communicating with and interacting with the citizens as policy gets made within the executive. So in a sense, I'm kind of accepting some part of the critiques you were talking about, in the sense that there is an issue of the democratic legitimacy of that process, and at least we've got something, right? But why don't other countries have it? Well, we can argue about that, but one basic point to make is that in a parliamentary system, if you don't have it already in the Constitution ahead of time, there's no political, no strong political argument for passing such sets of constraints. If you've got a unit, if the executive is representing the same political coalitions as the legislature, why would they pass a law that would impose some constraints on the executive? And similarly, if you thought you were going to bind the hands of future governments by going through a process to make things happen, well, it's much easier to change statutes than it is in the US. We really have a problem, as anybody who knows about the US situation right now, we really have terrible problems in getting anything done. And because of the complicated way in which laws get passed, which puts additional weight, on the administration and the way it operates. And you see some of these fights, playing out right now. But it does seem to me that part of the agenda of comparative administrative law can be to try to connect the study of the public administration and its competence and its lack of corruption or level of corruption and its connection with the underlying constitutional structure of the government, but being open to arguments that there are some weaknesses or some tensions in the relationship between the constitutional structure and some normative principles you might have about how administration should be operating in a way that is consistent with democracy. And that means, to me, focusing partly on the rulemaking part of it, as well as on the case-by-case adjudication individual part of it. So it's, for me, a reason why comparative administrative law is so fascinating is that it opens up some of these very basic principles or very basic questions about the relationship between government structure and the accountability of the government to its and responsibility of the government to its own citizens. So thank you for your paper. I only had your 5-page summary, but that seemed to be a fairly enlightening or communicated to me, at least I hope, pretty much what you were about. So thank you.
Thank you very much, Susan. Thomas, the floor is yours for a second round of reactions on Eduardo's ideas. Thank you.
Thank you very much, Mariolina, and thank you very much, Isa, for inviting me and for putting up with all my emails last week. I enjoy, and thank you, Eduardo, for sending me your piece, which I enjoyed very, very much, and I really think it's very interesting to have a more continental law view on this debate. Which has concerned for the moment only the US, obviously, but also some scholars in the UK. I'm thinking of the review that Paul Craig made of Hamburger's book that was really enlightening. I was also very interested in this debate and just would like to give you some food for thoughts from a very French perspective also that I assume. Because I was wondering when I read your piece and Hamburger's ideas and Dicey's ideas, to what extent it could relate to my experience as a French administrative law scholar. And the first question I asked myself was going back to Dicey and perhaps understanding from this debate on some elements that maybe have not been seen before. And my intuition, as a matter of fact, before the first COVID stroke, I was in Oxford and tried to see many archives about the teaching of administrative law in Oxford in the 19th century. And I was really surprised to see how little law teaching was done in the law faculties, not in the law faculties, because there was no law faculty at that time in the UK, and Dicey was pretty much alone, I think, as a lawyer in Oxford at that time. And from France, it relates to something because administrative law in France could really develop once it's separated from private law. And my wonder when I looked at all the curriculum and all the exams for the Inns of Courts in London, in fact, the only administrative law textbook they had in the 19th century to pass the bar exam was Blackstone. So I think at that time, one of the elements was the ideology of the common law. And in France, we had the ideology of private law that didn't allow for a real thinking about the administration, really thinking administrative law from a perspective that's not private law. And fortunately, we had at that time the Conseil d'État that forced us to think differently because it established principles really distinct from private law. But Dicey didn't have this. And I really wonder if this, in the 19th century, at that time, if there is not something in the ideology of the common law that explains this misunderstanding. And yes, first maybe element, not in politics, but in the politics of our disciplines. And we have, there are politics in our disciplines, at least we do have in France, and many fights between disciplines over some topics. And I wonder if this cannot be one element of understanding. For instance, in France, the field of regulation in the field of competition law and financial markets was taken over by private lawyers, and it had a very profound consequence on the field of regulation and the way process became more and more important for regulatory authorities. Also, one other aspect that I try to understand is why we don't have this debate in France. Well, also because in France, the administration is all powerful. We have high civil servants that are also politicians, are in private companies, and so the difference with the US, and there is a recent book by a political scientist called Kevin Brooks. The title is very telling. The title is Why Neoliberalism Failed in France. It's in English, published by Routledge, and he shows that compared to the US, and he always compares with the US civil service or the US structure. And he shows actually that it's easier so neoliberalism had much more consequences in the US because universities are much more independent, because the civil service also changes, whereas the French civil service is a life tenure, and they begin in the civil service at 25 and end up at 70. So ideas don't change as quickly as they change in the US, and the change of paradigm is always longer to take shape in France. And so, yes, there are ideologies in my country don't penetrate public action as easily as they would someplace else. Also, I was wondering whether in the difference with the US, maybe in France, at least is not linked to the Republican ideology that we have in France. The French Republicanism in the 19th century is not as attached to negative liberty, to borrow Isaiah Berlin's ideas, concepts, as the US. By that, I mean that in the US, Republicans especially think that the state is bad. It should not encroach on people's liberty. So negative liberty is very strong. Whereas in France, since the Third Republic, the conception of liberty, to me, is more the one that Philippe Petit and Quentin Skinner have developed, republicanism as non-domination, that tie together freedom and equality. And I think that the public service notion that developed in the 19th century and beginning of the 20th century ties up equality and liberty in a way that it does not in the US. And the public service in France is tasked with ensuring this freedom from social hierarchies through universal education, security through social redistribution, and protection against arbitrary administrative power through a very robust and open system of judicial review. So I wonder if the difference, at least between France and the United States, is not, yes, linked to this, for my country, less emphasis on negative liberty and more on states or the public service helping to free individuals from social hierarchies. And the reverse thing is that actually in Europe, we may have less anti-administrativism, so to speak, but I think we have more anti-parliamentarism, which also has negative effect, at least for France. And we have some anti-parliamentarism that also comes from the high civil service. And at the end, I wondered if we do not have in Europe a different way of coding the American debate. In other words, we wouldn't say is administrative law unlawful, but is public service and bad? Or in other words, we would target more public services, promoting privatization, for instance, than administrative law. And also we are using neo-managerial concepts that seem more neutral, to enforce deregulatory policy. In other words, we wouldn't say is administrative law unlawful, but we would say we are all for simplification, better regulation, smarter regulation, which are other ways less politically charged to say probably the same thing. These are my ideas, and thank you very much for inviting me, and Eduardo for reading your piece.
Thank you very much, Thomas. I would say, Eduardo, these were quite rich comments that were provided to you. So I want to give you the opportunity for a first round of reaction on these thoughts and suggestions. And then you can, for the audience, you can already start gathering your thoughts, and I will open the floor after this first reaction by Eduardo. Thank you.
Okay, so really many thanks to Susan and to Thomas for your observations. I mean, you have been two fantastic discussants, really. First of all, I apologize because the original paper was not so long, but it is in Italian in any case. So that's why, because it's going to be published in Italian, I will do also an English version, but it was too early to let you have the full text. But you got, all the main points, and you made some fantastic observations. So ideally, I should do a sort of, new paper based on what you've said, but this is impossible. But let me try to say two or three things, trying to combine what you said, because I found your comments very much complementary, although you moved apparently from two different backgrounds and perspectives. I'll begin with the last point made by Thomas, that is to say that there might be some hidden anti-administrative thinking even in Europe. So we don't formulate like this. We don't have Sustin and Vermeule, labeling these thoughts as anti-administrative thought, but there might be something similar in a disguised way, which I think it's interesting as a point, because it's true that we buy a number of ideological positions or points of view which are typical of anti-administrative thinking, and we import them in an overall framework which is, on the other hand, completely in favor of administrative law, the regulatory state, and so on, and which is interesting even in comparative terms, because it's a way, it's a form of circulation between, ideological positions, even operational positions, outside the traditional and more visible channels of circulation of institutes and rules. So it's true, there might be some communication between our thinking, our European thinking, and the US administrative thinking. And it's also true that there can be a number of really relevant bridges. Second, very short reaction. It's important to in a sense, in this discussion, it's important to differentiate between the conceptual framework or the conceptual level or the level of ideology again, and legal reality, because the two things go together, they stay together, and they are part of the same wider reality. Legal concepts make sense in relation to legal reality, and legal reality, of course, makes sense in relation to the concepts. So how? Let me do this example. Let's go back to Albert Ben Dicey that Thomas has mentioned before. The position of Albert Ben Dicey was a position which was, yes, probably purely ideological. It was purely conceptual. It was a negationist interpretation. But the important thing is that, it denied the existence of a reality which nevertheless was there. So he wasn't able, or he didn't want to see something which was there in the legal reality. So legal reality is important in this discussion. When we address in a scientific way these dynamics of the legal system and the position taking at the conceptual level and what happens in the legal reality, we have to understand whether there is some form of communication between these two plans. And here, and this leads me to my third reaction, which is probably the main point made by Susan, and which was somehow inherent also in the comments made by Thomas. That is to say that there might be something in US anti-administrative thinking, and probably also in the hidden European anti-administrative thinking, which is correct, is right, because it points to some shortcomings of legal reality, and it helps us to focus on something which is not doing well and that perhaps needs some form of correction. And this was what Susan said in relation to the third critique, the illiberal nature of administrative law. Now here, I must say that I entirely share your premises. That is to say that we need to, reflect on the way in which the constitutional values may be, or the way in which US administrative law, but European administrative law, any kind of administrative law in contemporary polities has to be adapted or made coherent with the overall set of constitutional values. And I very much share the view that rulemaking is one of the key issues in this regard. And I also share the view that we need to develop, participatory values, that there are, solutions that we might develop, but that we need, to engage in this regard. But you know what? Perhaps we should clarify a bit is the fact that I still see a difference between your position, Susan, and the position of many other administrative law scholars taking this point of view, and the position of those who have been, I think, rightly labeled as anti-administrative thinkers, for two reasons, I would say. First of all, because you know your position, your point of view, your perspective, and your approach leads to reinforce administrative law. It is the kind of perspective which leads to the reaffirmation of the potentialities of administrative law. Administrative law is at the same time the problem, but also the solution. So we can find a number of solutions within the field of administrative law, provided that we have the sensitivity and the and also the technical capacities and skills to rethink administrative law more coherently with the constitutional values. But the solutions are within the field of administrative law, while it may be paradoxical, but the position taken by those who oppose administrative law is precisely that we need to reduce the scope of administrative law. And here, basically they see administrative law as a problem because administrative law is illiberal as such, because they assume that administrative law reinforces the administrative power, while you assume correctly, I think, and it's my own perspective also, that administrative law can do and has to do both things. And the second reason is that once that we move to a more operational level, you mentioned accountability, which is, of course, the main overall concept capable of bringing together a number of possible adjustments to reconcile administrative action with the constitutional values. Accountability, again, is an instrument which is typical of administrative law. We can go back to Goodnow. Your position is the same position as Jerry Machaut, as I understand Jerry Machaut, but also we can, trace back this position really to Frank Goodnow at the end of the 18th century, because he was right since the very beginning. That's the problem. And while if we consider if we compare the idea of accountability, a complex understanding of accountability, not accountability, not a simplified artificial version of accountability, but if we take seriously accountability, and if we compare this sophisticated understanding of accountability with the solutions envisaged by those who argue against the liberal nature, or those who argue that US administrative law is not liberal, what is interesting is that what they stress, what they have in mind, is a way of interaction, is a way to recover some kind of co-regulator or co-regulatory interaction between agencies and the judiciary. And that's the problem, because accountability does not have to do also or only with the judiciary. It has to do with many other things. There is a bureaucratic accountability, the legal accountability, or many types of different accountabilities, while what they have in mind is something different. They have in mind a form of control over the regulatory action of federal agencies carried out by courts, which of course is part of our own understanding, our shared understanding, at least here in this panel today, of what administrative law should do, but it's only a part of the story. You cannot really conflate accountability within the relationship between regulatory agencies and courts. And once that you focus on this specific relation, it's difficult to understand what courts should do in relation to regulation. So what is the difference, for example, between a regulatory choice that has to be taken by a regulatory agency and legal reasoning, purely legal reasoning, which is to be left to the judicial court. So what I see here is, your comments, both the comments of Susan and the comments of Tomás, I think they are sort of, celebration of administrative law that I share, a celebration of the risk and the potentialities of administrative laws. That administrative law has to be developed, and we need to do our part. It's not satisfactory at all. We need to improve it. But we are not celebrating, the death of administrative law, at least in this panel. While, the other position is more subtle. So there is something that we can learn, I think, from that debate. But we also have to be aware that, we are much more positive about administrative law. And we are much more positive because we understand that administrative law has a number of potentialities beyond, let's say, power establishing. Sorry, very, very confusing, but, it was a reaction to your very stimulating thoughts. Thank you.
Can I just add something? I think it was striking. The three of us didn't really talk about courts, and yet they've become they are extremely important. And particularly in the US now, you're seeing courts asserting a kind of a role that's very intrusive in the way in which the administration is operating. And yet the courts don't have any staff. They have a few, no staff. They have law clerks. But, in terms of really taking on the review of the technical aspects of regulation, they can't do that on their own. And we will have to see how these recent cases, which kind of have shaken up the US field. I have a young friend who's just starting his teaching career and trying to, figure out how to teach the field of administrative law. So, you've got some judges who are very much very negative about the administrative state, and yet they are willing to take on for themselves quite, or not just for themselves, probably really more for the lower courts, a quite aggressive role. And it will be important to see how that works out. I mean, as you were pointing out, there's some debate over whether particularly the case overruling Chevron is important or not. I mean, there's language in it could go, either ways. And the concern is partly that the caseload of the Supreme Court is very small, and the possibility of all kinds of stuff going on at the lower court level is quite high, in a way that will not easily be overruled or dealt with by the judicial system. So it's that basic problem of the lack of capability of the judicial system to handle some of the issues that they themselves have raised in the context of that relationship. So that's it.
Thank you. Thank you very much to Eduardo, but also to Thomas and Susan for the wonderful discussion. And I would like to open the floor now for debate and Q&A. Please raise your virtual hand that I can give you the word. I don't see any hand for the moment, so I can abuse my position as chair to maybe bring in the mix the European Union, Eduardo, because of course your entry point, let's say, in this debate was very much a theoretical one, of course, but it felt also very much ingrained in the national legal systems, let's say. Now, when you bring into the mix the multi-level nature of European administrative governance on the one hand, and also the very fragmented way in which the administrative governance really of the European Union at the EU level is structured, with the lack of an APA and also the very strong resistance at the Commission level against any type of uniformization of administrative procedures. So where does that lead us in this discussion about how we should feel in that sense about administrative law? How does this apply to the EU administrative state?
Yeah, this is an incredibly difficult question. So I will give you just my impression. Okay, as you know, I have worked for many for 25 years, perhaps even more on EU administrative law. So it's supposed to be my field of expertise, but it's difficult in this case to make a comparison which makes sense. Okay, I have three reactions. One is my overall understanding is that the EU is basically reproducing the continental Europe model of relations between administration and the legislator, basically. So we are building a model in which administration has a constitutional foundation as part of the executive. So we don't have, let's say, the original sin that we can find instead in the American constitutional and administrative history. Although this constitutional foundation of the administration, the executive power, of course, has to be clarified. It has to be formalized in a different way. We have a treaty, not a constitution. We know all that. But basically, from a functional point of view, I don't see the problem that I find instead unsolved in the constitutional history of the US. Second, I would say that it's true that we don't have the APA, we don't have a number of traditional, instruments of administrative control. But when I've tried to develop in an article that I've written with Joanna Mendes for the evolution of EU law, edited by Paul Craig and De Burca, when I've tried to reconstruct the evolution of administrative law, I had the clear impression that it's a positive development at the end of the day. It's something that really is characterized since the very beginning on the idea that administrative law has to operate as an instrument of control of administrative power. The concept of accountability is a newcomer in our discussion, and it has been taken from the Anglo-American debate. It's a newcomer because it has been introduced not before, I would say in the last 15 years, perhaps 20 years, not before that. But we had many other instruments, and including conceptual instruments, such as, for example, the idea of the Rechtsstaat, the Stato di Diritto, or the rule of law, relying on the English language. So we had a number of instruments, and we had also a number of operational instruments. So I'm quite positive about the development of administrative law in this sense. Fragmentation, as you were saying, is a problem, of course, but it's not an unsolvable. It's not a problem that we cannot address. It's a problem that we can actually manage. It's a peculiarity in relation to the US experience because we have this composite EU administrative law system, but we can, we are finding, even or let's say both by through legislation and through the European Court of Justice case law, a number of solutions that are feasible, and they have some practical effects. So I think the overall assessment is positive. What is less positive, and this is my third short reaction, is the fact that we are still in search of a normative foundation for EU administrative law. This is really the unsolved issue in our legal history. And the reasons perhaps are clear, but we have to find a solution. The reasons may be clear because the EU has taken a rather instrumental approach towards administrative law. So administrative law was one of the components of the legal system which was supposed to be as a whole functional to economic integration. So it had to be, it was there for that specific reason. It was generated in the competition law field, state aids, the internal market, and so on. So the normative foundations are basically functional. So there is no, a political philosophy behind the development of administrative law. While I see, perhaps I'm wrong, but well, I see a great pressure of political philosophy over US administrative law. The discussion is animated also by the fact that administrative law is not immediately coherent with, a specific political philosophy, and in particular with the democratic values that Susan Rose Ackerman was mentioning before. So we need to reconcile. While in Europe we don't have this, I don't see this sensitivity in the literature, in our discussions, even in the public debate about the evolution of EU administrative law. So we need. Now, this is the lacuna that we have to fill, I think. We have to begin to think in more political, philosophical terms about EU administrative law. We should do what Susan is doing in relation to US administrative law. This is something which is missing at the moment. And of course, it's a problem. One way would be really the accountability concept. The accountability concept, I made a presentation I think 20 years ago in an Italian-German colloquium in München, and it was about the introduction of the concept of accountability in EU administrative law. And the Germans were, they were not happy, because they told me, we have all an entirely different legal conceptual apparatus to address the issue of control of public administration. And I try to defend, to do my best to defend the relevance of the accountability perspective. And this wasn't, illuminating for me, because I realized that through concepts you can really, reshape also operational, specific, instrumental legal institutes and rules. And I think accountability has a great potential, provided that we use accountability. Well, my favorite quotation here is Jerry Mashaw's understanding of accountability, when he says that we have to unpack accountability and we have to build accountability regimes instead of, being satisfied with the number of specific instruments of accountability. So I think we should take seriously what US reflection on accountability can teach about the normative foundations of administrative law. This is, I think, the black box at the moment that we have to, reconstruct and rethink. And comparative administrative law from this point of view is really, the fundamental context, or the fundamental field of encounter between all scholars who have the same, ambition to imagine that administrative law is not, a set of technical solutions, but also a number of technical solutions framed within a democratic political philosophy.
Can I ask you a question? So I agree that the term accountability, it covers a lot of things, but just to put out two particular ones. One is having to do adjudicatory mechanisms, right? You're deciding an individual case, and the discussion has to do with how accountable to certain human values, rights, protection of rights, or whatever that process is. And there's another box, which is what we've more been talking about, which is accountability in the context of rulemaking or of choices which have broader, kind of policy applications. And so I wondered, within the EU context, whether there's those two different strands of talking about it and how that's playing out.
Yeah, there are, this basic ramification has been, internalized, I would say, in the administrative law scholarship in the EU, and it has been copied from the APA and from the American culture, of course. But there is still a difference in the sense that we have much more advanced instruments of participation in relation to individualized proceedings than in relation to rulemaking. But there are also some promising steps in that regard. And after all, comitology, I don't know if you are familiar with an article written by Francesca Bignami about comitology and notice and comment in comitology, which was published, I think, in the early 2000s, which was interesting because she brought the attention to the fact that, in relation to the specific situation of the comitology procedures, we were copying the notice and comment arrangement. So we don't have, all the details or all the distinctions of the APA in relation to the rulemaking procedure, but we got the basic idea. Let's say interest representation. We got that idea. Then we have to develop it, but we are not following a different lines. We are, this is my understanding at least, we are, arriving later. And there is a problem of time management, so to say, but we are going in the right direction. And in this sense, I would say that the EU is doing better than its member states, because most of the member states have problems including Italy, in recognizing a set of participatory rights in relation to rulemaking. Final comment, and then I'll stop. But what I would like to understand is whether this fundamental distinction between rulemaking and individualized proceedings is capable of capturing all the possible manifestations of contemporary administrative power. Because the EU from this point of view is an interesting laboratory. You see, for example, regulation by information according to a very famous formula by Maione. We have different types of experimental regulation or regulatory action, which does not fit very well in the general framework of rulemaking. So notice and comment could not be a unitary solution or participatory instrument to manage all situations. So there is an evolution of the regulatory instruments, and I would like to, it's something that I have to I don't know now, but I would like to do some research on this. I would like to understand whether we can develop further participatory instruments beyond notice and comment or rights of defense, according to the situation, or whether we should abandon, or we should, let's say, integrate the idea of participatory rights with other types of participation to a process which cannot be proceduralized. It might be the case that there are situations in which you don't have any more administrative procedures because of the experimental nature of regulatory action. For example, when you publish an information or when you use new technologies. So, I am totally sympathetic. I'm just with you. I'm just wondering whether, the evolution of regulatory techniques may go in the direction of an evolution also of participatory instruments, participation without procedures, so to say. It might be, I don't know, but please let me know what you think.
Yeah, no, interesting. Good. A lot of things worth thinking about.
Thank you. I see Dominique with virtual hand raised. So please, you have the floor.
Hi. Very glad to join in, and I was quite happy to listen to all the author and the discussants, as well as yourself, Amalia. I might want to make 2 points. I do see that the anti-administrative state campaign, because for me it's a campaign which has been shaping up for several decades, in fact, I do see it as having a replica, a manifestation in continental Europe. I don't think that this is something per se specific to the US discourse around the state. I see that as more as a general anti-state discourse. And to me, the moment when, in fact, the anti-state campaign also developed in Europe was exactly around the time when the so-called network services were liberalized, whether under the EU law itself or under the national European national systems themselves. I do recall I was abroad at the time. I was in the US when the most of the reforms were conducted. But I do recall in particular that in the case of French administrative law, when that whole development took place, when private law was infused in some kind of increasing way into public services law, the point was made by some that, well, that was the end of French administrative law. And there was a real discussion as to whether, well, it has some future. So the point is, of course, that we know it is there and it is there to stay. So what I'm trying to say is that for some scholars, whom I would perhaps characterize as the neoliberals, and I am in disagreement, by the way, with one point made by an English scholar, that British scholar, I should rather say, that Thomas reported about when he said, well, why did neoliberalism fail in Europe? I'm not sure that it really failed. I think rather that it does not, I mean, the success of it does not take the same shape as the very strong shape that it has in the US. But I do view the whole idea of saying, well, public services which were really representative of state intervention in the economy have to be brought under the common law, here common law meaning private law, competition law, as a way of saying that what is meant to be a specific law was to be let go of and should be replaced. And the result, as we speak, is that we have a stronger admixture of public law-based rules and private law-based rules applicable to public services. So I wouldn't so much say that it is a hidden agenda in the EU and in the member states, as I would rather say that it is more subtle. It is phrased differently, and Thomas, I do agree with you on the point you made as far as saying that, well, it is certainly not called the abolition of the administrative state in France. It would rather be called the reduction of the public services inputs into the economy, but it is actually at the root, I think it is the same. The second point I might want to make relates, in fact, to in those who campaign for the abolition of the administrative state, it seems interesting to me, and this is a paper I am currently working on, to note that arguments that were articulated against what at the time in the 1930s was seen as an emerging or increasing, not really emerging, but let's say increasing US administrative state. And the arguments that have been developing along the same line in the US in the past, we would say 20 years to past 2 decades, they are similar in some regards, and I am referring to the way comparative law is used there. At the time, and right now I see exactly the same, there is whether openly, and that was certainly the case in the 1930s and 1940s, and I would say nowadays in a more hidden way, there is in fact a hidden, I said, or more or less open borrowing of the administrative court idea from continental Europe as being a way to rein in the so-called administrative state. So to me, there are two things to note, and I will wrap up my 2 points as follows. That we should not make so much of a specific case about the US, although we do have to say that it has peculiar features as far as the call for the abolition of the administrative state. And I should also second point out in terms of articulating the anti-state discourse on the part of the US campaign managers, if I may say, we do have to take into account some of the borrowing, and that's where, of course, a comparative law comes in good hands. I think I have spoken too long, sorry.
Thank you. Thank you very much, Dominique. Seeing the time, Eduardo, 1 minute really for your reaction before we wrap up today's seminar.
Okay, no, many thanks. Yeah, you are very much, you go beyond Thomas Perroux, actually, following the same line of reasoning in the first of your 2 points. Just a short reaction on this. Yeah, it's the French discussion of the early 2000s about the death of administrative law is fascinating for me. It was accompanied by a parallel discussion coming from the German culture on the transformation of administrative law. So there was, a legal culture arguing that administrative law was dying, and another legal culture arguing that administrative law was very much alive, and because of this reason was trying to evolve and change its features. My reaction is the following. I don't think that this is really that this provides some evidence about the fact that we have in Europe some hidden anti-administrative thinking. I think that what the French authors that you are referring to were saying was that administrative law was changing its features, its originary features. So it was developed in France with some very specific and characteristic features, the connection with the state, the provision of public services, as you said, and the speciality, of course, special prerogatives and so on. While Jean-Bernard Doby and the others actually pointed to the fact that the law of public administrations was now supposed to use a variety of different instruments going beyond those traditionally associated to administrative law. I think this was the main part. This was the way in which I read that literature. And from this point of view, the conclusion would be that, yes, administrative law is dying, perhaps, but we still need some kind of law for the functioning of public administrations. And this law is a mixture of public and private law. We need to rethink the overall rationale. We need to understand how these elements stay together, but we still think something which is about the executive implementation, the administrative implementation of legislation. And from this point of view, I still see a difference with the US debate, which is much more about, a negative attitude towards the regulatory state. And, precisely because of this starting point, it's also a reflection against administrative law. While what the French scholars are saying is that administrative law is losing its original purity, which is different, I think. But just a reaction before the sum up given by Mariolina. Let me thank that it has been extremely fascinating and interesting discussion for me. I learned a lot, and it's not always the case. So really, I'm grateful for all your comments.
Yes.
Thank you very much. Thank you, Eduardo, also from our side, from the editorial board of the Review of European Administrative Law, for accepting to share your thoughts with us. Thank you once more, Susan and Thomas, who unfortunately had to leave, for their really rich discussion and insights. And the next appointment of the dialogues is set for the 2nd of December, where we will talk about local communities and local government and EU law in the multi-level context. More information will be circulated soon, but follow us on X and on LinkedIn, and also we have a dedicated website where the abstract of the forthcoming dialogue together with the speakers will be published very soon. For now, thank you very much again, and have a nice rest of the day and afternoon. Thank you.
Thank you.
Thank you very much. Thanks a lot.